Good day, Crime Talk aficionados. That's right. It is the weekly recap for all the top stories that we brought you the week of August 5th, 2024. And I say it again, the weekly recap. So you don't need to tell me, hey, didn't I see some of this? It's a recap of the top stories. Now, if you haven't seen them, it's a great way to get caught up on everything that's going on. We hope you enjoy the show, and we'll see you next time.
All right, lawyer.
Next, the Karen Reed case. I don't know. Is the prosecutor going to fold to the defense in this particular case? We're going to have to wait and see. But the prosecutors basically made a filing late Friday, letting everybody know that 4 jurors in the Karen Reed murder trial contacted the Norfolk County District Attorney's Office, with one saying that Reed was unanimously acquitted on 2 charges and that she was accused of the charges she was accused of, including murder. The assistant district attorney received an unsolicited voicemail and 3 emails from an alleged juror on Sunday, July 21st, who claimed it's true that what has come out recently about the jury being unanimous on charges 1 and 3. And then on Friday, July 26th, prosecutors say that the prosecutors received another unsolicited voicemail from the same individual stating, can confirm unanimous on charges 1 and 3 as not guilty, and as of last vote, 9-3 guilty on the manslaughter charges on the lower level manslaughter charges. Now, the prosecutor's office didn't respond to the jurors due to ethical violations about the juror deliberation process, and the DA office also claimed that prior to that, they had received 3 emails from individuals identifying themselves as jurors who wanted to speak anonymously. And then on July 16th, the Commonwealth reportedly responded to the email stating that they would welcome the opportunity to discuss the evidence or the Commonwealth's case. However, we are ethically prohibited from inquiring as to the substance of your jury deliberations. That would include your individual or the jury's collective thought process, the content of your deliberations, or the reasons for your decisions. All 3 alleged jurors declined further communications after saying the DA's office couldn't promise their confidentiality. Ethically, the prosecutors are doing what they have to do. Do they have to dismiss, the counts where the jury said 1 and 3? No, the verdict was never officially taken. I know there's one case out there that allows them to do that. Now, if the justice requires such, the DA can decide if that's what they're going to do. I don't see the judge imposing not guilty verdicts on that. And the reality of it is, ladies and gentlemen, nobody asked. Nobody asked if they had reached a decision on the verdicts. They basically just assumed, because the notes were very articulate, well written, and stated we were hung. They didn't say we were hung on 1 of the 3 counts. They made it sound like they were hung on all of them. So now everybody wants to have their cake and eat it too. The one who really, the judge says, fine, mistrial, defense asks for mistrial, you got it. Prosecution was like, no, don't do it. They got the mistrial. Each jury is different. To say that the charges should be dismissed, that's a decision the prosecutor will have to make. I don't think it's one for the judge, but each case is different. I've, like I said, had cases where it's been a hung jury and, guess what? You go back and do it again and they all come back guilty. So each jury is different. There's personalities involved, lots of different things that can take place. I think Karen Reed is going to go back and we're going to do the same trial all over again. We'll just have to see what the judge decides in an upcoming hearing. Well, Justin Timberlake and why he is going to plead guilty. All right, we're getting more information about the Justin Timberlake DWI arrest. And this is about as generic and Jane plain as you get for a DUI refusal. DUI, DWAI, same thing. DWI, all means the same thing. All right, driving while impaired, driving under the influence, basically as long as the BAC is above 0.080 or higher. All right, so first, apparently Justin Timberlake reeked of alcohol and was unable to follow police instructions correctly when he was pulled over under suspicion of driving in the Hamptons back in June. New police documents provide new details into the traffic stop which explain why he failed a series of sobriety tests, refused a chemical test, and was ultimately arrested. Like I said, he was pulled over shortly after midnight by a rookie police officer by the name of Michael Arkinson, who allegedly witnessed him blow through the stop sign and swerve in the right lane. That's certainly reason to pull somebody over, no doubt. The police paperwork also shows that Timberlake verbally refused a test 3 times and even refused to the initial document confirming that decision. Now, Arkinson, the police officer, handwritten notes appear to show that the officer followed procedure in the field and determined that Timberlake displayed numerous signs of intoxication, such as swaying on his feet, turning the wrong way, and being unable to keep his balance. Now, Timberlake was alone in the car and was observed to have bloodshot and glassy eyes, odor of an alcoholic beverage emanating from his breath, and an inability to divide attention, and unsteady on his foot. Inability to divide attention simply means you can't do more things than once. Hey, can you get me your driver's license? Can you give me your insurance? Those types of divided attention type of issues. Anyway, the officer stated that the singer said in the report that I had 1 martini and I followed my friend home. Well, that admission in and of itself was enough for probable cause, but wait, there's more. He also noted Timberlake was unable to focus on speaking while looking for his vehicle registration. And the walk and turn test requires the defendant, Mr. Timberlake, to take 9 steps in the straight line, each time placing his heel directly in front of the toe, then to turn and repeat the process. Now, according to the police officer, Timberlake was very unbalanced and was unable to follow those instructions correctly. Timberlake was then asked to raise 1 foot slightly off the ground, keeping it raised for 30 seconds without moving. The police officer also reported that Timberlake swayed while taking this test, needed to use his arms to keep his balance, and put the foot down before the required 30 seconds had passed. And the 4th test in the field was the pre-screened breathalyzer that Timberlake refused to take. That's the little portable breath test. Anyway, so while the results of the breath test are not admissible in court under the portable breath test, they can be used to establish probable cause. I'm of the mindset, and most judges are, and courts are, the law is that if you admit to drinking, that's probable cause to submit to a alcohol test because you expressly consent to give a test if they believe that you are operating a motor vehicle under the influence of alcohol or drugs or a combination of both, ladies and gentlemen. Anyway, the officer then placed Timberlake under arrest, handcuffed him, and then put him in the backseat of the car. Atkinson took inventory of Timberlake's property, which included a Rolex watch, a vape pen, a gold ring, a wallet which contained 3 $100 bills and a $5 bill, and 1 single. He also asked Mr. Timberlake to take a breath test at the police station, the results of which would be admissible in court. But according to the police report, Timberlake refused and said, no, I'm not going to take a chemical test. Now, by 1:26 a.m., he was read his Miranda rights and told the officer that he understood them and that he did not want to speak without an attorney. Good move. Could have made a couple of other good moves, Mr. Timberlake. The next details of the report come after Mr. Timberlake was rearraigned on the driving while impaired charge in the virtual court appearance last Friday. During the hearing, the judge suspended Timberlake's driving privileges in New York for at least 1 year, could be up to 2. And appearing, Mr. Timberlake pled not guilty to 1 charge of driving while intoxicated. Now, the hearing came after Timberlake's attorney sought to dismiss the case, citing some errors in the paperwork. So the prosecution said, fine, we'll fix the paperwork. Get your client here. Like I said, he was allowed to appear via WebEx. That's Mr. Timberlake. And guess what? Timberlake's attorney withdrew his original motion once the paperwork error was dismissed. And the judge also admonished Mr. Timberlake's attorney for his comments, saying that they are irresponsible. Those are the comments that he made to the press after the previous court appearance. So really the bottom line is, will Mr. Timberlake plead guilty to this charge? Eventually he will. Now he's got a court date on August 9th. Do I anticipate anything's going to happen then? No. Why? Because he's still off on tour over there in Europe, and then he comes back to the United States. But he doesn't have to appear in person. But this is a standard routine DWI, DUI, wherever they call it in your particular state. He was over the limit, .008, and the reason why he's going to plead guilty, at least to a reduced charge, more than likely of driving while ability impaired, is that that's normally what would happen at court. 1, he admitted to drinking. 2, bad driving, failing the roadside sobriety test, which he could have refused. That's why when the police officer says, would you like to take some voluntary roadside maneuvers? Well, if they're voluntary, then I will respectfully decline them. Okay? This is what they refer to, as a double refusal. You refuse to take the test, you refuse to take the breathalyzer, you refuse to give a blood draw. Anyway, given the circumstances here, though, a reasonable jury could conclude that he was driving while his ability was impaired, like a .050 to .799, okay? And that's what will ultimately happen, is my prediction in this particular case. This is a routine, boring DUI, DWI, like I said, whichever they call it in your particular state. These happen all the time. It's a classic, pleaded down to a driving while ability impaired and move on. Now, here's the thing that the prosecutors are going to argue at trial. Now, they'll usually get a jury instruction saying that there's a presumption that basically you should take the test, right? Think about it, ladies and gentlemen. If you are walking out of the store, right, you bought some clothes, and they put those little metal tags on them, and you walk through the metal as you're leaving the door, and they beep, 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 beep. What do you do if you've paid for all your items, right? You stop and you say, oh my gosh, something here. Here's the receipt. Take a look at it, right? It's the same thing with a breath test or a blood test on a DUI, right? For example, I don't drink. I would love to get pulled over and somebody accuse me of that. I could be like, you know what? Let's go take that test right now, and it's going to be all zeros, and let's go do this thing, right? And so if there's that one opportunity, that one test that can say, I'm not drunk and you're completely wrong, police officer, and everything you've said, everything you've observed or you said that you've observed has been completely wrong, and I'm going to show you. But he didn't. He refused the test. That's why he's going to plead guilty, ladies and gentlemen. Chad Daybell had a hearing. Now, he wasn't there. It was on Zoom, but we brought it to you live, and you can check it out. And his new attorneys want an extension in which to file their motions. They're still getting up to speed on the case and frankly haven't even reviewed the transcripts, although they did produce a 200-page document explaining why they need more time and the issues involved. Now, you may say, well, what's the big issue? Just do the transcript, do the appeal, right? Well, it's going to take time. And this is what's different on a death penalty case. A lot of states have adopted a system whereby if somebody gets the death penalty, instead of immediately just going to the appeal and starting that process, and then when the appeals are exhausted at the state court level, then you go back and then you begin the ineffective assistance of counsel claim. Now, a lot of states say, let's do this all at once. So instead of going to the appellate process, the attorneys are appointed. They then investigate and file their petition for basically ineffective assistance of counsel. And the new attorneys for Chad Daybell did bring out that there was virtually no mitigation done whatsoever. Now, I'm sure there was, but hey, what are you going to say about Chad Daybell? He's a really nice guy until he killed his wife and, married another woman and killed her kids too. Everything was good up until that point, but we're really only there about up until that point. So anyway, that's what the attorneys are already saying, is that Mr. Pryor was ineffective counsel for Chad Daybell, and they want to be able to add more time. The problem is in Idaho, for these attorneys, there's various statutory time limitations that need to take place. So they were asking for more time. The prosecution also needs to file their responses because basically it turns into a civil proceeding at this point, is the way it was explained in the hearing. And so there's a lot of things going on, but everybody's agreeing they need more time. Pryor's new attorneys and the state are going to file kind of a joint motion. The judge then has to file basically a request to the Idaho Supreme Court to get permission to grant more time, which undoubtedly they will. But this is what we anticipated all along. We knew that there were going to be ineffective assistance of counsel claims anytime you lose on a big case. Mr. Pryor's problem is we don't know exactly what he did, but he didn't present any mitigation. That may have been at the client's request for all we know. But the point is, it's going to take time. It's going to take years. And we're going to see a knockdown drag out. Now, here's always the interesting things when it comes to post-conviction relief. the prosecution and the defense didn't particularly get along with Mr. Pryor, right? The prosecution didn't exactly get along with Mr. Pryor. Now they, being the prosecution, are going to have to defend everything that Mr. Pryor did and say that he was the greatest attorney ever to step foot in the state of Idaho and that Mr. Pryor could have got no better defense. Frankly, I think he did a pretty good job with what he had to work with. But it's the post-conviction attorney's job to try and get a new trial or at a minimum vacate the death penalty. Their goal is not to get Mr. Pryor released. Their goal is to avoid the death penalty. Mark my words, ladies and gentlemen. That's right. Brian Kohberger's attorney is going to be busy. I hope this doesn't affect the trial date in Mr. Kohberger's case. So the lead attorney for Brian Kohberger, obviously, he's charged with killing 4 University of Idaho students back in November of 2022, will also be the lead defense attorney in another high-profile case in Idaho. That's right. Now, Ann Taylor, Kohberger's top attorney, was assigned Wednesday to head up the defense of Skylar Mead. Now, that is the Idaho prisoner who is charged with killing another man there in Idaho after escaping from the corrections officials at a hospital in Boise during a shootout in March. So like Mr. Kohberger, Mr. Mead faces the death penalty if found guilty by a jury. Now, Kohberger's murder trial is scheduled to start in June of 2025, while Mead is set to be arraigned Thursday in the Nez Perce County Courthouse. Now, initially, another attorney was assigned to represent Mr. Mead, but the attorney did not meet the qualified requirements and can only be co-counsel in this case and wasn't qualified to do the lead counsel issue. So Taylor is only one of 13 public defenders and kind of alternate private counsel in the state approved by the Idaho Public Defense Commission to work as lead counsel in a death penalty case. She is also the only one grouped in that northern Idaho area where it seems like there's a lot of killing going on. Anyway, if you didn't already know this, Taylor left her position last month as the chief of the public defender's office up there, and she has now transitioned into private practice. The attorney, Jay Longsdon, who is also co-counsel on Kohberger's defense team, is now acting as the interim chair for the public defender's office. Now, Mead, who is serving a 10-year prison sentence in the Idaho Maximum Security Institution, was taken to the hospital in Boise after prosecutors say he faked an injury. Mead had coordinated a plan to escape from the Boise hospital with the help of the alleged co-conspirator, Nicholas Umpenhor. Yes, the plot thickens. She is going to be busy. Like I said, I've said this in the past, the death penalty cases, we had one that was considering going death. We convinced him not to, so we didn't do it. But everyone that I've known that has done a death penalty case, they usually had one death penalty case, and it was a full-time job. So to have 2, that's right, she is going to be one busy lady. So she must be good. I think she's good. I really do. I think Miss Kelly is very good. Every time I've seen her in court, she runs circles around the prosecutors in that case. All right, the Karen Reed case. That's right. There was a hearing this afternoon. We brought it to you. Obviously, what the defense attorneys are doing for Karen Reed is try to have at least 2 charges dropped in her murder case, which is obviously scheduled in Massachusetts, not only for this motion, but for trial after the first of the year. Now, as you may recall, her first trial on the 3 charges began in April. Count 1 was to the charge of second-degree murder. Count 2 was the charge of manslaughter. And count 3 was a charge of leaving the scene of an accident with injury or death. Now, the prosecutors had a couple of difficulties during their presentations of the case to the jury as it relates to Karen Reed, including some surveillance video from a police garage that appeared to be inverted and some embarrassing text messages about some very regrettable text messages sent by the Massachusetts State Police trooper assigned to investigate the case. That trooper was later suspended, and others have faced internal affairs investigations as a result of that. Now, Karen Reed's first trial ended in a mistrial on July 1 after the jury of 6 women and 6 men repeatedly informed the judge that they were hopelessly deadlocked. Subsequently, both the defense and the prosecution informed the court that some jury members came forward to report that the panel was in agreement that Reed was not guilty of 2 of the 3 charges. Now, I personally don't think the judge is going to reconvene the jury to question them about this issue. Basically, the defense they're saying because they have information from jurors, they believe the judge can enter a verdict of not guilty on these charges. And obviously that's what was argued today. Now, the prosecution has some precedent, says you can't do this. I don't think, I'm have to agree with the prosecution, okay? And I'm no fan of the prosecution, okay? But I just think the judge, everybody got it wrong in this particular case, and that's just what happens. So the judge took the matter under advisement. No real idea when the judge will issue an order. But if we're taking bets, I'm going to say denied. Anyway, the prosecutors have said that they will retry the case, and the new trial is scheduled to begin on January 27th of 2025.